dispute resolution field. Mr. David was awarded the Dispute Resolution Award of the Year, Global at the Prime Disputes Award 2024. Next, we are honored to have Mr. Karan Kanwal with us. He is a dispute resolution practitioner with diverse experience in civil and commercial litigation, insolvency, international and domestic arbitration, mediation, commercial contracts, and legal advisory with over 15 years of experience before the Supreme Court of India, the Delhi High Court, the NCLT, and the NCLAT. Mr. Karan has an extensive experience as counsel in commercial arbitrations, both ad hoc and institutional in India. He provides legal services from a business perspective and has experience in advising businesses on contracts and ADR. Mr. Karan has represented clients in arbitration matters, boards, and regulatory bodies. He has an experience in vetting and reviewing contracts and transactions, advisory on project management, regulatory issues, tender and bidding documentation, etc., in various sectors. He is currently serving as Deputy Registrar at IIAC. Then we have Ms. Vishruti Sahani. She is a Principal Associate in the Disputes Practice at JSA Advocates and Solicitors. She specializes in corporate commercial litigation, arbitration, insolvency, and regulatory disputes, with a particular focus on advising leading technology, fintech, and infrastructure clients. Her experience includes handling high-stakes arbitrations in litigation arising out of government contracts and public-private partnerships. She regularly appears before courts and tribunals across India and is widely regarded as part of the next generation of leading dispute resolution lawyers. With such a distinguished panel, we are set for an engaging and illuminating conversation. I encourage all participants to actively engage by posting your questions in the chat box. Without any further ado, let's begin with this vital discussion. I'll now hand over to our moderator, Ms. Vishruti Sahani, to kick off the dialogue. Thank you.
Thanks so much, Mahi. I thank you for that introduction. I think this panel has its reputation that precedes each of us. If I can say that about myself, but I can definitely say that about all of my more senior panelists. I think the topic doesn't need much of an introduction. I think we've all been talking about how arbitration is the most preferred mode of dispute resolution for commercial parties. But what the paradox we're dealing with today is that one of the biggest commercial players or the biggest litigators in India is quietly seeming to walk out of it. So I'm going to first do a round of quick thoughts from each of our panelists. And the thoughts that I want is on whether in your respective experiences and your engagements with different wings, departments of the government, are we saying that is this really, is this going to be the rule or is it an exception? Is it a few one-off contracts or is it the trend that the government is now seeming to take or the path and the approach that the government is now seeming to take? If so, and either way that your answer goes, I would like you to address in maybe a couple of minutes on why you think that this shift has happened or why this exception came about. So ladies first, so I'll have Mehak's initial views on this, please.
So I think it intends to be something that's going to have a ripple effect. Definitely for the worse, according to me. I'm a victim of these government contracts in my field. So because PWT, NHAI, they've already come up with their circulars, right? So I think the other government entities are soon enough going to follow suit. So yeah, in terms of my quick thought, yeah, I think everyone's going to copy the trend very soon.
Robin, thoughts from you, sir?
Yes. In fact, if you look at the office memorandum of 3rd June by the Ministry of Finance, it clearly says arbitration is good, is speed, etc. But it also says there are certain peculiarities that the government has. That is, for example, government officers keep transferring from time to time, and therefore the fact that the opposite parties have continuous law officers. So the government is at a bit of a disadvantage. It also raises some very serious allegations, if I can use that word, because it says that the process of arbitration is very long. It doubts the independence and integrity of the arbitrator very categorically. So therefore, it says now you go ahead and reduce it beyond 10 crores, you should not take steps. So this is definitely going to have a ripple effect, as Mehak has very rightly said. And it also raises some serious questions. If the largest litigant, like you said, the largest litigant is itself doubting the credentials of its own arbitrators, then we have some problem that we should really address as an arbitration community. And also, I see that there are some institutions represented here, and some major thinking has to happen at a very high level, so that we can be somewhat closer to our other jurisdictions, like at least like Singapore or any other such jurisdiction.
Thank you. Talking about institutions, we'll turn to Karan for his initial views on this.
Yeah, hi. Thank you so much, first of all, for having me here for this panel discussion. And coming to the topic, in my view, I think that, removal of the arbitration clauses in the government contracts is more like a risk management strategy by the government. However, at the very same time, the government and the government wants to make India a hub for international arbitration and domestic arbitrations, of course. So, promoting institution and, setting up an institution like India International Arbitration Center, which is the only institute in the country having coming up after the, based on the statute, in my view, is a welcome reform. So in my view, we are stuck in between two things, where the government at the one time is, having a risk management strategy by, coming up with these clauses. At the very same time, it is also promoting institutional arbitration. In my view, I think the government in the past has, seen the difficulties in the ad hoc arbitration. That is why also it is very important for us to, see the difference between ad hoc as well as institution. So is what I wanted to say here.
Thank you. Akash, quick thoughts from you, please. Sorry, Akash, you're on mute.
Oh, sorry. Yeah, thank you very much. So I have 3 points, quick points to answer this question. So from 2014 till 2019, if we look at the ease of doing business index ranking, India improved quite a lot in the overall ranking. But if we look at the enforcing contracts, which is one of the criteria, India improved a meager like 10 ranks or something. So the overall enforcing contracts rank is still 163rd. This is one of the reasons to attract investments. The government tried to come up with a lot of amendments like 15, 19, 21, 24 draft bill. But if we look at the recent set of notifications, first starting with the Ministry of Finance, 3rd June 2024, they said that up to 10 crores will have arbitration, but not beyond that. 21st April 2025, the PWD Delhi notification, they said that let's scrap arbitration. The third one is 12th June 2025, where the NHAI said that we'll have a multi-tier dispute resolution clause. Well, we'll have 3 steps before moving to arbitration, and they did not provide a clear-cut timeline. So if we look at the trend is, of course, that we have to go for arbitration. But with the recent set of changes, we can see that India has created a paradox that we want to have arbitration, but we also want to scrap at some point of time. We also want to have multi-tier dispute resolution clause. So, and those multi-tier dispute resolution clauses are not well drafted one because they don't have a proper timeline. So what India is currently doing is India is showcasing that we are taking a step forward, but India is taking 2 steps backward because we are not creating a very good framework for these arbitrations. So it's a paradox. Yeah. Thank you.
I think if I may say, I think if you draw an analogy, it is like you're launching a national marathon training program and you're banning the running shoes.
Exactly. That's the paradox.
It's, I think when we were trying to put together a piece on this, we keep talking about if justice is delayed, justice is denied. But if arbitration is denied, it's litigation that gets multiplied. So where are we really going from here? If there has been this reform that we have been trying to speak about or we are propagating globally, where does that today keep us or put us on this global paradigm, where on one hand we have not only institutions or litigators or litigants, but government, our minister going out and talking and promoting arbitration across the globe. But coming down to a little more practical impact of this, Mehak, I'll come back to you because you mentioned that you deal with this on a regular basis, and I think you, like you said, you're a victim of this more than I don't know if anyone else over here. But again, just going back to the why of it, because I think that's the perplex that we are all on. Do you think that this is a dissatisfaction with the process altogether? Or is this just a move to consolidate control over dispute resolution, just going back to the old means of litigating and running from court to court?
So I think it's a bit of both. Actually, one goes after the other. So I think it's the dissatisfaction of the arbitration which has kind of led to their need to consolidate the control in their hands. I mean, I think like all of us were talking, it is a way to manage their own risk. If you would go back into the timeline before the Ministry of Finance gave this guideline, and just very recently, in the sense, I think in December 2023, there was the Haryana Industrial and Infrastructure Development Corporation lost a case to a consortium of banks that was, I think, led by IDBI, which was a 2,100 crore arbitration. Then moved to April, we had the famous DMRC where 3,000 crores was at stake. And then there's another litigation which hasn't yet been, hasn't really closed out. It started in 2010, which is ONGC versus Reliance, where it's about this production sharing, right? Where they're alleging that Reliance is using unauthorized, it's taking unauthorized access to the adjacent fields to extract the gas. So that started in 2010, and in 2018, they won the award in their favor, Reliance, and then it was upheld again in the division, on the single bench in 23, and then it was struck down on the division bench in 25, which is now in Supreme Court. So if you look at all of this entire timeline, they're really trying to, what has happened is this is reactive. They're trying to contain the political optics of it. They're trying to manage the risk. They want to manage the narrative and the exposure. So let's just say, I think it's kind of a convenient setup for them that as long as they want to promote foreign investment, arbitration is great. But the moment they are the respondents, then they want to pull back on the process and make sure that the mechanisms are something that they can control. So I think that's the paradox even the others were talking about. So that's what's really happening in creating that conflict.
Okay, thank you. That's actually very insightful. I think it's very experiential as to why you think that came across. And I'll just turn to the academic in the room and just go back to Akash to understand, do you think there could be a policy logic behind this? Do you think it's purely from a...
You go on mute.
I'm sorry, we should be...
Sorry about that. So I'm saying that, what do you think that there's a policy rationale behind it? Because, I mean, the policy development on this area has been exponential in the pace in which it has grown, the manner in which it has grown. So do you think that there's a policy shift that we are seeing coming in? Or again, is the public sector separating itself out from how the private players and the corporates are going to be acting in its dispute resolution clauses?
I think, like, if we look at the notifications by these PSUs, especially the first one, the Ministry of Finance Office memorandum, where they discourage the disadvantage, where they provide the list of disadvantages of having arbitration, they don't clearly provide the reasons for it. But they said that, arbitration is something which is taking time, it's not cost efficient. So I think, of course, there have been certain thoughts, for example, lack of trust in arbitration. One of the reasons can be, of course, what Mehak ma'am said, that when you don't win the game, you just, keep on changing the rules of the game. That's, of course, one. But the other one is, of course, the time, cost efficiency, all of this. But I think the larger problem which the government should also understand, and this is my personal view, that if you are saying that it's taking more time, it's taking more cost and all of this. So I was checking the National Judicial Data Grid before joining this call. And the total number of cases pending is 4.65 crores. I'm not only talking about the civil cases, I'm talking about all the cases, because in India, we don't have like a civil judge and a criminal judge and, let's say, an arbitration judge. So there are different benches, but of course, all of the judges are involved. 33% of the posts of judges are vacant in India. Then we have Delhi High Court, which is one of the leading high courts, 36 judges out of 60. Allahabad High Court is running on 81 out of 160. On one side, the government is saying that because it's taking more time, it's having more cost, there are delays in Section 34. Okay, so it's a cyclic argument. One side, the government and the PSUs are saying it's taking time. The other side, we are not moving to arbitration, we are not moving to privatization of justice. I'll just give you one example from Singapore. So when Singapore was having a lot of arbitrations, they also came up with something called the International Commercial Codes, where what they have is different judges coming from different parts of the globe, and they have all this time limits mentioned, they have the amounts mentioned, and you can directly go there. And those codes are not like a proper domestic judges and proper domestic rules. So they have such an international forum, which is as fast as arbitration. And in one of the articles, Gary Bond said that if International Commercial Court of Singapore keeps on working like that, there may be a time that commercial parties will try to use IC, International Commercial Codes, instead of moving to SIAC or any of the other arbitration centers. So I think the problem lies with this, that it's a cyclic argument. We say that it's time, it's more cost, Section 34, all of this. But at the end of the day, if you say that we are pulling out of arbitration, you have to go for litigation. And in litigation, all of us will agree that how easy it is to resolve a dispute, especially in Section 34. Ma'am has talked about DMRC. We all know what happened in the Singh brothers case of this Daiichi arbitration case. So how much time in India it takes for enforcement of foreign awards is itself a debatable topic. So I think it's a huge policy gap. And this is where I say that the government has to come up with something called like an ADR policy. Just to give you a quick example, one of the example which India actually did in 2002, the amendment came in 1999, which was the CPC Section 1889. And later on 2002, it came into force. So basically, it was more like a national policy, a national law that we are going to give push to ADR. But after that, if we talk about one national law which applies to all parts of India, I think it's a gap. And this is the gap which everyone is exploiting. For example, PWD has a different notification, Ministry of Finance has a different proposition, state governments have a different proposition. So I think it's high time that from the top, it flows to the bottom. Because in India, we talk about awareness of arbitration, mediation. Nothing is going to change. We all know that if Shah Rukh Khan comes and say that if you apply Fair and Lovely, you will become fair. People follow it. People buy that product. If you have Virat Kohli coming and saying that, wrong t-shirt is something so attractive to, non-male genders and all of this, people will buy it. So I think it's high time that we stop talking about bottom to top, that, we should go to common man, we should convince them, oh, you should go for mediation. Why don't you go for mediation? I think it should come from the top. But what we see from the top, it's more like India is already a hub for arbitration. India is the best. I think Paris is last. So I don't know like what we are going to do with this. I think it's high time that we accept that we have to start with baby steps instead of saying that we are already a hub for arbitration. I think all of us will agree that we are not the hub for arbitration. We are not the most arbitral developed jurisdiction. Thank you.
Shah Rukh Khan needs to be talking about arbitration, Akash.
Somebody has to hire him.
Yeah.
Meg ma'am is getting marketing ideas already. But moving to Mr. David, just talking about what happens on ground from a more practitioner's point of view of what this is going to do. My question is actually in two parts. One is, what is this message that this is sending out to private players now, especially when it comes to cross-border contracts, etc.? How is that going to become or going to be impacted by this change? I mean, we were hoping and looking forward to a larger movement of more international commercial arbitrations coming in, more cross-border disputes arising out of these commercial contracts. So how does that affect this? And also, I had a larger question, which actually I put to everyone and, would like for them to respond in their respective terms, would be that, are we just looking at this shift to be something specific to redirection from arbitration? Or is it a redirection from all forms of alternate dispute resolutions? Or is it a redirection to another form of alternate dispute resolution like mediation? So is it today them saying that, listen, we don't want to do any ADR, we are going back to court litigation? Or is it them saying that, you know what, we are not liking arbitration as this form of ADR, we are moving to mediation? So, I mean, the question is directed to Mr. David, but would also like everyone's thoughts on the other element of ADR and its impact as well.
Yeah, if you look at the circular, it seems to say that yes, we should go towards mediation. There is some indication on that line, and it talks of the Mediation Act. But I think there are some bigger problems that we have, and which we should actually face. And as far as arbitration is concerned, we definitely are not the hub. And we recently also had to see very senior judicial person's award being struck down by the Singapore court, which actually takes us many steps back. So there's some serious work that has to be done as far as our arbitrators are concerned. And if someone as senior as that does some simple mistakes, it doesn't augur well for the entire community. So that being said, the very fact that we are moving back from arbitration, it is a step backward, definitely, and it is not good for global investor confidence. And it is definitely not good for arbitrators, because I've been in practice for quite some time, and it is very hard for you to get your first arbitration. And with matters being taken away in this manner, it's just not going to help. So some serious institutional level thinking has to be done, and steps have to be taken. And we also have to look at ourselves, say, this is where we stand. This is where we stand. And we are actually an adversarial community. All of us are litigation lawyers who also do arbitration. So the moment the matter comes under 34 or 37, we become as adversarial as ever. That spirit of settlement, all those principles are completely out of the window. So it's important for us to actually have a specialized arbitration bar and specialized arbitrators. And retired judges are good, are trained, but we should look beyond that. Definitely look beyond that, because some of them are not making us proud.
Thank you for that very candid response. I'll now move to Karan. I wonder that from an arbitral or an arbitration institution point of view, is this shift or are these instances that are now happening, or these exclusions clauses, is this getting the arbitral institutions to rethink their offerings? Are they now thinking of perhaps promoting hybrid clauses or tiered mechanisms, or integrating mediation with conciliation tracks? So I'm just wondering how the reaction is. Are we going into promoting any other forms of these mechanisms that would then redirect arbitration into the institutions?
So, in my view, I mean, coming up with these kind of circulars, for example, if we talk about Ministry of Finance, I mean, the idea behind that circular was in relation to the procurement contracts, right? When you talk about, large stake arbitrations, if it is to be handled by the courts, then our courts are already overburdened with matters. And then with 34, 37, section 9, 11, all this increases the burdens of the court. When you talk about the construction arbitration, let's talk about the construction arbitration, building of roads, building of bridges, etc. Possibly those agreements and the contracts are running and into possibly 500 and 1,000 crores of claims. And with that amount involved in an arbitration or involved as a claim, it may have numerous amounts of documents. And if it is expected for the courts to have these numerous kinds of documents to be reviewed in a trial, it is going to increase the burden of an already burdened court. Now, when I talk about institutional, the government is promoting institution. I mean, IIC has been set up. Institution. I mean, at present there is a problem with regards to the fact that ad hoc arbitrations are preferred over an institution. Now, the problem lies over there. The mentality and the the mindset has to be changed. That the institution, the people needs to know that even the arbitrators can be appointed by the institution. In the institutions, there are many institutions in India. There are many institutions abroad. We as institutions, we have on our panel some of the specialist arbitrators. We do have former judges, but we also have other arbitrators who are having domain expertise. For example, if you have an issue with regard to the maritime law, it may not be expected for a retired judge to know the knowledge in relation to maritime law or any specific expertise in a particular subject. Hence, in my view, a more credibility of an arbitrator needs to be seen. If there is an institution, that institution can oversee an arbitration and can, there can be the credibility of the arbitrations can be seen. Arbitrators can be seen. That's what I wanted to say.
Thank you. And now I'm glad that you picked up on, or touched on construction arbitrations. And I think infrastructure projects is something that's sees the maximum arbitration and arbitration clauses with which actually get invoked and get into maximum disputes. So going back to Ms. Oberoi, that ma'am, how does the removal of these arbitration clauses affect large infrastructure projects which have, long execution periods, have complex dispute profiles, and are there any? Is there a revision in the legal and strategic options that are now available for contractors when arbitration clauses are unilaterally just now being removed from these large infrastructure projects?
So, it's a legal nightmare. It truly is a legal nightmare. I mean, if you're going to tell the construction industry or the infrastructure industry to move to civil courts suddenly, how is one going to explain to the foreign investors that come and invest money in my country, but I'm going to give you the only option of going to the courts as a dispute resolution mechanism? That is just, it's not dispute resolution, it's delay by design. It's actually dispute storage. And everyone has been talking about overburdened courts, etc., which is the case. We still have we have about 21 judges per million population, which was something that was 30 years ago, the Law Commission had recommended it to go up to 50, 30 years ago. And we're just at 21 versus Europe, which is at 220, and US, which is at 150. How can you expect that kind of load to be borne by the courts? And if you're trying to push to mediation, do you have the institutional capacity? Do you have so many mediators? You don't. You don't even have enough judges, and the courts have been around for eons. So either build your infrastructure first and then start putting your policies in place. Because the projects are such long duration. There are multiple stakeholders. You cannot plan your project schedule around disputes. So payments are stuck. There are interest claims. There are milestones that are getting stuck and blocked. So there is just so much. It's very difficult and it's very capital intensive. It's not just a delivery that I pick up something in a truck and I have to load it from here and unload it over there. There are just so much more involved at the project site that if you're going to try to take me to a court for everything, it's going to be a nightmare. But I think the only silver lining here is one, the guidelines are only for procurement right now, and the fact that they're not mandatory. There are government entities that are already following suit, but I think we still have some way to push the government into favoring some arbitration clauses. If nothing else, just trying to carve out arbitration for technical disputes, or talking about a multi-tiered dispute resolution clause. But again, it needs to have some teeth. You have to be able to allow the private parties also to appoint the mediators. You can't have the same run-of-the-mill recycled government officers where the private players really don't end up getting a say. You have, DABs today where even if I would win a case in my favor, the government entity will say, I need to take it to my board for approval, and the board will strike it down. So then what's the point? You're not giving it any teeth, even if you're giving me this process. And leave aside the fact that, first of all, NHA has come up with this ingenious idea of not giving timelines at all. They've introduced mediation and conciliation. Conciliation is supposed to go out of the window after the legislation. So they really kind of, I don't
Not
even have
thought
words
it
to
through.
describe what they've done. And then the timelines are not followed. So I really don't know what they're trying to do. What is the message that they're trying to send? I'm, when my stakeholders ask me, I'm at a loss of words as to how I need to explain what India is doing with its dispute mechanism.
Yes, we really have unpacked a quiet shift with very, very loud implications. What just seemed to be something that slipped in and out, I think we managed to unpack the implication, and your anguish has come out very, very clearly
In
the
2 minutes, I
last
could
segment
only
of
unpack this much.
no, but it's well received. But I think just taking from your experience and anguish, again back to Mr. David as to what is it that we could do now from a purely, well, I know you've also wear the hat of an arbitrator, but more from a litigator or an experiential point of view, how does a contractor or the non-government party now make a shift in its legal strategy or its strategy for litigation or dispute resolution with this coming in? Because see, there's nothing much we can do. Bargaining power, unfortunately, isn't even in such contracts. So where does that leave us from a purely strategic point?
See, from a Delhi practice point of view, I have had a fairly good experience with the commercial courts under the Commercial Courts Act. And things do happen fast, and some cases are decided within 1 or maximum 2 years. And it is quite effective. And some of my clients are also quite happy not having an arbitration clause, because like the government, some of the private parties also feel that the arbitration process is very slow and they don't have much faith in it. So that being said, I think as an arbitration community, we'll have to really pull up our socks and do a lot of hard work in building up the arbitrators, training arbitrators, and also for people to have faith in non-judges, because there's some impression that the judges would do it far better than experienced lawyers, which may not be the fact. So I think there's a long way to go, but with institutions like IISc and others putting in an effort, I see some hope, but it still seems a little bit far.
Thank you for that. Akash, you seem to have your hands up.
Yeah. Just following up on what Mehak ma'am said with respect to the arbitration versus the mediation debate happening in India, that some of the notifications say that we'll go towards the multi-dispute resolution clause. I think the larger problem is that when we go for non-arbitration mechanisms, it's not something where you have a mandatory resolution. Because at the end of the day, when you sign up for these mediations, there may be a settlement, there may not be a settlement. And I think that's something which was one of the reasons in the 2017 Sri Krishna report, where it was more talked about institutionalization of arbitration, moving towards this. And also, if we look at the Queen Mary survey, the recent one, 87% of the commercial parties want to resolve their disputes through arbitration. Talking about an Indian survey, which was conducted by Khetan, where they say that for small disputes, Indian parties, 75% opted for arbitration. For large disputes, 85% opted for arbitration. So if we go by these numbers internationally or the Indian survey, both of them reflect that there is a strong trend that the commercial parties want to go for arbitration. And of course, the only debate is more than 50% of the Indian parties say that it's ad hoc arbitration rather than being institutional, which is rightly pointed out by Karan sir. But I don't think that there is any debate in between arbitration versus the other areas. Of course, when we have multi-tier dispute resolution clause, if it is drafted very well, which Mehak ma'am talked about, with proper timelines, all of this, not repetitive steps, because the problem is also in construction industry, time is of essence. When you have so many steps to take care of before actually moving to arbitration, if there is no subject matter, the subject matter itself not there, so there is no point of moving to arbitration. Just two examples with construction adjudications and arbitrations. In Malaysia, they have a national law which is called the SIPA, for which all the payment-related disputes go to be adjudicated under the SIPA 2012 National Law of Malaysia, and Asian International Arbitration Center has the sole authority to administer that process. The courts do not have power with that. It's only the Asian International Arbitration Center. So basically, this is one example where they actually quite successful in doing a privatization of justice with respect to construction adjudication. Another small example coming from one of the Indian states is Telangana, where the Law Department of Telangana came up with an order stating that IAMC, Hyderabad, has to be the arbitral mediation institution in all contracts above 3 crores. And it has to be under the aegis of IAMC. I'm not sure about the implementation of the Telangana law and all of this with IAMC, because the notification came in, then I was trying to research on this. I didn't get much information. But SIPA 2012 is a successful model from the construction adjudication in Malaysia. But if we talk about something like a pan-India law on that, I don't think we have it in India.
Thank you for that, Akash. So I know that a large number of our participants here are students. And I know we're also at the last 10 minutes of this session. So we'll start with Karan sir, but I think one of the things that I am now finding about this paradox and coming out of the actual experiential issues and concerns that we're going to have in day-to-day practice, with the Arbitration Act being reformed, institutions being set up, everyone talking about conferences, about having these big international commercial arbitration, there are a bunch of students who are now geared up to be arbitration lawyers. and they want to, specialize. They want to be focusing on arbitration as a dispute resolution mechanism. I think a question that has, been now making the murmurs is that, do they need to reconsider that? Do they need to, go back to maybe focusing or realigning or just making their practice a lot more diverse and not more specific and more specialized to arbitration? And I think just with that question, I'd also like everyone's closing remarks on the topic and a few words for our students here who I hope are not more distressed by this panel and this conversation and have more positive takeaways than I think all of us have expressed through our anguish. So I'll turn to Karan sir for that first.
So, for the students, I must say that, arbitration is definitely one of the very good fields in which they can practice. Of course, apart from other civil and the other civil, criminal writ, other jurisdictions, of course, there. It is very important for an arbitration practitioner to have an expertise in the arbitration. And my advice to the young students present over here is that before to delve into the arbitration, arbitration is a very small bare act, but there is a large and various multifaceted things to it. Small little issues like there is a split, there is a setting of judgments on the difference between venue and place, and finally the Supreme Court settled those issues. What is very important is that the arbitrator, the parties to have faith in the process, in the arbitration, as well as in the administration of the arbitration. I wanted to actually supplement what Mr. David said, that the arbitration needs to have a specific bar. Arbitration should not be post 5 p.m. Work or maybe a weekend affair. It should definitely not be the case. India should definitely have specialized and expertise arbitration practitioners solely doing arbitration is the way that the arbitration can develop further. Of course, it's good for lawyers, though. They are in the court till 4 o'clock. Post 4 o'clock, they are doing arbitrations. But in my view, for arbitration to develop in India and to make India a hub for arbitration, we need to have a specialized arbitration practitioners. Of course, that was the reason. That's why the Arbitration Bar of India was set up. I don't know what is happening post that, but yeah, that was one of the agendas. Another agenda of the government was, of course, to set up IISc and there are other institutions as well. So, the government also doing a lot many things to promote institutional arbitration. I know that, the current law secretary as well as the previous law secretary has written letters to various PSUs to, adopt institutional arbitration within their contracts. So while the Ministry of Law and Justice is promoting arbitration and writing it to the PSUs to adopt institutional arbitration rather than having an ad hoc arbitration, whereas on the other hand, a few other departments are coming up with these circulars. Of course, in my view, that the arbitration is definitely one of the best fields in the legal profession. So for the law students present over here, I would suggest that they should think of arbitration as one of the fields in which they want to progress.
Thank you, Karan. I felt a little targeted by that statement because I'm actually driving down for an urgent 17 matter before an arbitrator on a Sunday. So the whole idea of having weekend arbitrations and litigating over the week is actually very, very real. And, again, moving to Mr. David, since Karan made reference to, your thoughts on having a specialized bar. I'm concerned with it and maybe a little afraid of that happening, but I do, of course, see a larger merit in it.
No, I think what Karan is saying is that we need to have a bunch of people who will be there for arbitration and who would take it extremely seriously, and that the clients, etc., will have their cases like any other normal court hearing. For example, an arbitration at 12 o'clock, 10 o'clock, not after 4. And that makes life a lot easier, because like you only said, if we don't have if we had a proper arbitration bar, then we will have a proper system where everything falls in place and it's in sync with the court, and more work for all. On a general sense, for the students, I think there is nothing to be concerned about. You are in dispute resolution, and we are from a very strong adversarial society, so there are bound to be disputes, and so just rest easy on that thought. So in order to work in this as a litigator, I think one of the most important things, apart from knowing the law, is to be in a good physical health. So and also mental health. So I think you guys have to spend some time on that, on your physical and mental well-being, and that is extremely important. Play golf, do something. I mean, don't take it too seriously, the whole game. And as far as the future of arbitration is concerned, I think it is there to stay. It is well established internationally, and we are going to have more and more international trade, etc. So there's no getting away. It's going to happen, and sooner than later, the government will make things easier, and they maybe withdraw this 3rd June circular also. So there is hope, and just rest easy and move forward.
Thank you. Akash, just a few words from you, and then we'll move to Mehak ma'am to close the session.
Okay, so I'll try to answer this for the law students. So 3 quick points. First, more complications will lead to more opportunities in ADR and dispute resolution arbitration. So I don't think there is anything to panic about this particular field. And because arbitration is evolving dynamic subject, and it also has an international flavor attached to it. For example, the New York Convention, which is signed by more than 170 countries. So it's actually an international topic. So it doesn't matter much that whatever is happening within the Indian context, at the end of the day, domestic arbitrations, institutional arbitrations, ad hoc or foreign arbitrations are going to increase. This is the last point. It doesn't matter that whether you will choose dispute resolution as a career or not, but at the end of the day, dispute resolution will find you in some way or the other. So you have to at least keep up with this tradition, and if I have to call Gen Z term, you have to match the vibe with what's happening within the domestic and foreign arbitrations, because at some point of time, you will be involved with this. Thank you.
Thanks, Akash. Ma'am, to you for your final comments.
So I think with respect to the law students, I think literally you have nothing to be scared of. The time is now, because when I started 18 years ago, the only thing that you did is either corporate law or criminal law. There was nothing in between. And maybe 5 years after that, IP started becoming a specialization. But today you have construction law, you have maritime law, you have space law, you have sports law. So the world is your oyster. You've just got so many fields to get into, even as far as arbitration is concerned. If you become an expert arbitrator, your career will know no bounds at all. So I don't think you have anything to hesitate about as well. And mediation is going to be the next arbitration 7 years from now. So you start training yourself in that direction as well. You've got a lot of scope than we had when we started out 2 decades ago.
Okay, thank you for that. I think just my closing thoughts on this, that I mean, to all the students in the audience, that you might not be seeing arbitration clauses in public contracts, but you're still seeing them in your exam papers and in your syllabus. So don't give up on it so soon. And I will now hand over to Mahi and the MediateGuru and the organizer for any questions and answers.
Thank you so much, ma'am. This really was an insightful session. And I can say I'm not afraid of arbitration or studying arbitration in general. Moving to the Q&A segment, there are a few questions from the participants. Firstly, a question has been put regarding the proposed amendments to the Arbitration and Conciliation Act of 1996 in 2024. They ask, how will the inclusion of an appellate arbitral tribunal impact arbitration and litigations which arise therefrom? Whoever wants to take it.
Sorry, just can you repeat that?
So the question is in regard with the proposed amendments to the Arbitration and
Yeah.
Conciliation Act of 2024.
Yes.
They ask, how will the inclusion of an appellate arbitral tribunal impact arbitration and litigation which arise therefrom?
Yes, assuming they have faith in the system and in the tribunal, I think it'll work perfectly well, and it will actually reduce the time consumed in the whole litigating for arbitration proceedings. So it would be positive, and it's a very good positive step.
I think Akash has something to say.
Can I add on to this?
Sure, sir. Yes.
Yeah. So Section 34A, which is in the draft bill 2024, which provides that there needs to be an appellate arbitral tribunal. So basically, the draft bill has an objective of stating that we'll have this power of Section 34 being delegated to an institutional arbitration. So I think the larger idea of the draft bill is that if we delegate this power, the institution will take care of Section 34 challenges. So from a bird eye view, it looks very good. It's a very progressive step. It's a pro-arbitration approach which they have taken. However, this is not something which has been tested by the leading jurisdictions in arbitration. If we talk about the French courts, they have still kept the power of setting aside with the national courts. Of course, there have been minor examples like Poland and some courts where they have tried to delegate this power to the institutional arbitrations. I think the larger criticism of this is that how they are actually going to, provide a resolution with respect to public policy, because the courts are given this power to, define public policy and all of this. So it looks very pro-arbitration approach, but the larger problem is how the Indian institutions are going to cater to this. Because at the end of the day, the institutions are going to nominate the arbitrators. So it looks very good that it's a delegation of Section 34. Instead of courts, the institutions will take care of this. So it will save a lot of time. But the problem is the implementation part. And I think personally, it looks very good step, but I think it will be a challenge to define something like public policy and adjudicating the borderline cases.
Yes, sir. So I believe that answers that question. Moving to the second one, they ask, why is it that private parties can exercise party autonomy, but the state and its instrumentalities alone are tasked with this unilateral duty to promote arbitration, even if it goes against their interest? Even the state has the freedom to contract.
I'm not sure I grasped that question completely. When you're talking about party autonomy really means both parties can choose. I mean, talking in terms of arbitration, you can choose your seat, your arbitrators, and all of that. Now, I'm not quite sure what you're trying to say in terms of the state. If at all someone has to promote arbitration, it has to be the state, right? Because no one else has the right to do it. They're the only ones who can issue the guidelines, the policies, etc. So if it has to be promoted in the country, it has to be done through the state. So I don't know whose question was this. Am I missing some? Bhavat Maj, is it? Or
Yes,
Suganya?
ma'am.
Why
It's
don't you
Bhavat
speak
Maj.
up? I just would like to understand a little more of the context. Have they dropped off?
Excuse me, ma'am, am I audible?
Yeah, you are.
Yes, ma'am. So I just had this small doubt. I'm a student only, so I'm asking as a doubt only. So my question here is that, like, even the courts, when it comes to commercial matters, they treat the state as an equal party. They don't treat the state as, say, the state. They treat it as a commercial party only, with having its own interests to keep in mind. Similarly, in the context of arbitration, if the state thinks that arbitration is, say, against their interest, why can't the state exercise its discretion to decide, say, we don't want to use arbitration because it's expensive, let's use a regular court process, or let's use mediation, or let's use
Got it.
any other process as per our own interests, keeping our interests in mind.
Got it. Okay. So let me first bust your myth that you think both the parties are equal. When you're contracting with a government entity, they're not equal. The government always has the upper hand. And so when I talk about having a dispute resolution clause in the contract which says courts or it says arbitration, I am by default supposed to accept that. I don't have the option of raising my hand and saying that, look, I don't want courts, or I don't want mediation, or I want only arbitration. So that's the myth that I wanted to bust. So I am the one who's always at the receiving end as a private player. I don't have an option to negotiate it out. So it's really, I'm literally, I have no say in the matter. So I think that should hopefully answer your question.
Okay, ma'am. Thank you very much.
And also, I think there are two scenarios: state acting on a policy level, and state acting in a particular specific contract. So they are two different things. They can't be equated.
Understood, sir. Thank you very much.
Panelists, there's the last question by Suganya. She's asking, is it not an overarching expectation to demand that India match the state-involved arbitration models of Singapore or cautious openness in France or USA when our ecosystem is still evolving? Will it not creating tiered ADR frameworks for public contracts seem the practicable way ahead, at least in the short term?
I think Akash, you should take that one.
So just to answer this with an analogy, so you're inviting your guests to your house and you are not opening the door. Then how that guest will come to your house for the dinner? So when you ask this question that why we should follow this, Singapore model or France model, I'm not saying that we should follow everything blindly. For example, French courts also have this biasness towards arbitration. So for them, everything under the sun is arbitrable. I'm not saying that we should completely blindly follow the French principles. There have been authors who criticize that, and I agree to somewhat extent. But for example, if there are certain disputes which can be arbitrable, and there have been trend in India also, and arbitrability is just an example. So previously we used to say that it's a very less subject matter list which can be arbitrable. Now India is also moving forward. All we are trying to say here is that we should take the best practices from all around the globe, especially from the developed jurisdictions. I'll just give you another example. So recently I was looking at a LinkedIn post that UK Arbitration Act has been revamped. In 2025, they have a new law. If you ask me personally, even their old law was pretty much fine, but still they are updating. If you look at the Singapore International Arbitration Center rules, every time they keep on, updating it, coming up with new rules, which is not the trend within the Indian jurisdiction. So all we are trying to say is that we should follow the best principles. We are not saying that you should completely, ignore the Indian matrix, geography, language, culture, all of this. But we have to make sure that some of the basic things, for example, Karan sir was talking about, role of institutions. Why do we need institutions? Because of a very simple reason. You have a certain rules which is notified on the IIAC website, and you can check who can be appointed. There is a list of arbitrators. But and let's take the example of Robin sir when he said that there is a senior member of the judiciary whose arbitration award was challenged, was actually rejected. Now, do you think that all of this, unless until you have an institution where you check the qualifications of the arbitrators, I think it's very good. Instead of having an ad hoc arbitration where you just choose your arbitrators randomly, a lot of debate is also happening around the globe with respect to diversity. And if I have to call diversity, it's more like non-male genders, especially like there is a debate about this. If we look at the number of female arbitrators or non-male arbitrators, all of us know that there is no equality numbers all over the globe. Forget about India. In India, we know that which sector has been ruling over the number of appointment of arbitrators. If we look at the institutions, it's pretty much better than the court-appointed arbitrators. It's very difficult. One of my students was writing a paper, an empirical study, on Delhi High Court appointing non-male genders in arbitration matters because they have a lot of arbitration referrals to DIAC. It's a very less number of percentage for non-male genders. So all we are trying to say is we should follow the best principles. And these are the best principles coming from the best institutions and best arbitral developed jurisdictions. So I think the good things we should follow.
You need to aim for the sky. That's the only way you'll at least land up on a treetop.
That answers it as well. To the participants, Akash sir has dropped his contact details for answering any further questions. Now, if assuming that there are no further questions, we draw to the close of this session. On behalf of MediateGuru, the Center for Advanced Dispute Resolution, CADR Jindal, and the ADR Society, National University of Juridical Sciences, it is my distinct pleasure to deliver the vote of thanks. First and foremost, our deepest gratitude goes to our truly distinguished panelists, Ms. Mehak Oberoi, Mr. Robin Ratnakar David, Mr. Karan Kanwal, Professor Akash Gupta, and Ms. Vishwati Sahani. Thank you all for sharing your invaluable time, profound insights, and diverse perspectives on such a critical and complex subject matter. Your expertise has not only eliminated the paradoxes within India's ADR landscape, but also provided pathways for deeper understanding and future action. We as students as well are immensely grateful for the thought-provoking discussion you have facilitated here. We would like to extend a heartfelt thank you to our esteemed collaborators, CADR Jindal Global Law School, ADR Society, NUJS. Your partnership is invaluable and your commitment to fostering crucial legal discourse is also truly commendable. And finally, a special thank you to all of you, our wonderful audience. Your active participation, keen interest, and insightful questions in the chat box truly enriched today's session. We hope you found this discussion as enlightening and engaging as we did. Before you leave, please remember to take a moment to fill out our feedback form. The link is being shared in the chat box now. Your feedback is crucial for us to continue organizing relevant and impactful events. We hope to see you at our future events as we continue to explore and unravel key issues in the legal world. Thank you once again for joining us this evening. Have a wonderful day ahead. Thank you.
Thank you.
Thank you.
Thank you very much, Mai. Thank you very much, everyone.
Thank you.
Thank you.